USCIS has recently issued an important document updating its policy guidance about EB2 and IWs. This document provides interesting clarifications about how USCIS officers evaluate and adjudicate NIWs and about the type of evidence petitioners can use to support their case. The first key highlight of this updated policy guidance is about the EB2 classification. USCIS says that somebody who is seeking to apply for the NIW has to first demonstrate that they are eligible for the EB2 classification as either an advanced degree professional or an individual of exceptional ability. An advanced degree is either a master's degree or a PhD or a bachelor's degree followed by 5 years of progressive experience in the specialty. About advanced degrees, USCIS makes three interesting clarifications. Number one, the petitioner's occupation in the United States, meaning the occupation through which the petitioner intends to advance the proposed endeavor, the proposed activity in the US, has to be a profession, meaning that it usually has to require a bachelor's degree to be able to do it. This is telling us that holding an advanced degree is insufficient. Simply holding an advanced degree is insufficient. A petitioner has to also demonstrate that the occupation in which they intend to work in the United States is one that typically requires at least a bachelor's degree. Number two, a petitioner that does not hold a master's degree or a PhD and that intends to rely on a bachelor's degree and 5 years of experience accumulated after the degree has to demonstrate that the experience is directly related to the field of the degree. So you cannot have, let's say, a bachelor's degree in chemistry and have 5 years of experience as a music teacher. So the experience after the degree has to be related to the degree itself. And clarification number three is that if the professional occupation requires a degree in a specific field, then the experience has to usually be related also to the proposed endeavor. USCIS also clarifies that for professions that do not require a degree in a specific field, USCIS will interpret the petitioner's specialty as related to the proposed endeavor. The second key point of this updated policy guidance is about exceptional ability. Petitioners who do not have an advanced degree can qualify for the EB2 category as individuals of exceptional ability. And USCIS is clarifying that a petitioner's area of exceptional ability has to be related to their proposed endeavor in the US. Another important key point of this policy update is about the national importance of the proposed activity, the national importance of the proposed endeavor. And about this, USCIS reiterates the difference between an occupation, which is something more general, and the proposed endeavor, which is more specific. Occupation, let's say, is engineer. The proposed endeavor is designing, developing systems, processes, etc. So what you will actually do in the United States, your occupation is being an engineer. The proposed endeavor is what you will actually do as an engineer in the United States. And in multiple parts of this updated policy guidance, USCIS encourages clear and straightforward descriptions of the endeavor. They don't want complicated, complex descriptions, even for cases involving technical, highly technical endeavors or occupations. They encourage clear and straightforward descriptions of the endeavor. Then USCIS clarifies that a proposed endeavor generally holds national importance if it has national or global implications within a specific field, if it has significant potential to employ U.S. workers or other significant economic benefits, if it has the potential to broadly enhance the welfare of the American people or to enhance their cultural or artistic enrichment, or if it contributes to the advancement of an important technology or field of study. USCIS then provides many examples of endeavors that could be considered nationally important, and also many examples of endeavors that may not be nationally important. And the common denominators about all these examples is something that I would say us NIW practitioners have known now for a long time, and it is that a petitioner's endeavor can not only benefit the petitioner's immediate circle. The benefit has to go beyond the petitioner's immediate circle to be of national importance. Finally, about national importance, USCIS clarifies that where there is an occupation with a shortage of talent, a national shortage of talent, and you're seeking to go and you're seeking to work in that occupation where there is the shortage, this per se will not be sufficient to demonstrate, that what you come to do to the United States is nationally important. Another key highlight of this updated policy guidance is about the well-positioned prong, and USCIS provides a non-exhaustive list of evidence that petitioners can provide to demonstrate that they are well positioned to advance their proposed endeavor. Another key point is about the balancing prong, and USCIS provides criteria that a petitioner can use to satisfy this prong. Again, they state that shortage in a given occupation would not by itself satisfy this prong, and providing these criteria and this list of evidence is not something I would say novel, as practitioners have seen these criteria in these documents many times in RFEs, in NOIs, in appeals. But it's nonetheless, it's important that USCIS is making this clarification in this way, and it is available to the public. Two other key points are about STEM professionals and entrepreneurs. And for entrepreneurs, USCIS says that general claims that entrepreneurship generally benefits the economy is insufficient. So entrepreneurs have to also demonstrate that what they want to do in the United States holds national importance. And as far as STEM professionals, USCIS acknowledges that the significance of STEM professions now with a more specific emphasis on critical and emerging technologies and on STEM areas related to U.S. competitiveness and national security. Definitely an important update as far as policy guidance for NIWs. It does not reveal drastic changes, but it gives us a lot more insights as to how USCIS officers evaluate, interpret, and adjudicate NIW petitions. And in my opinion, this document does two things. First, it is available to the general public. My personal opinion is that USCIS has received a lot of NIWs prepared by non-attorneys, either petitioners by themselves or non-lawyers. And by providing this guidance, USCIS is seeking to, I would say, get better prepared petitions. The second thing that this updated policy guidance does, again, my personal opinion, is that this guidance is also directed to officers. It will be reflected in the USCIS policy manual, which is what immigration officers use to adjudicate cases, right? So it provides immigration officers with clarifications about how to interpret NIW petitions. And what I'm hopeful for is that it will contribute to more uniform NIW decisions so that us NIW practitioners can have a better feedback to be able to better assist our clients.